Welcome to my court case presentation. Today I'll be focusing on two different cases, the first being Furman vs. Georgia, a 1972 Supreme Court case that is seen as a significant criminal case in which all prior legal constructions for the United States death penalty were invalidated. And the second being a follow-up by the name Gregg vs. Georgia in 1976, where they dove deeper into the Furman case, where Gregg wanted to rule the death penalty itself as unconditional but the court refused to do so. For some background, the death penalty is a criminal punishment where the criminal is killed for the crime that they've committed. The most common form of execution is a lethal injection, as it is said to be the most humane, but other methods are still authorized, such as electrocution, hanging, gas chambers, or firing squads. There are two different ways one could be sentenced to death. The first is a federal death penalty where the final decision comes down to the United States Attorney General. The second is a state death penalty where local prosecutors determine the criminal's fate with no input from the state attorney general. The sentence is then decided by an unanimous jury. Crimes that can lead someone to end up under the federal death penalty are the murder of a state official, the murder of a state correctional officer, kidnapping and then killing someone, murdering a court officer, or anything similar. These offenses. State death penalties are more individual as they are determined by the state, but most states will execute someone for offenses such as murder with special circumstances, military sabotage, or fatal assault by a prisoner who already has a life sentence. Now that you guys are all well informed, let's get on with the cases themselves. The reason this case was held was because William Henry Furman was committing burglary in someone's house. During his trial, Furman stated that while he was escaping, he tripped and the weapon he was carrying accidentally fired and killed the victim. As suspicious as this already sounded, it was also contradictory to the prior story he told the police that he blindly fired a shot while escaping. Furman was found guilty, mostly due to his own statements. Remember, if you're telling a lie, you should at least have a consistent story. Furman vs. Georgia was a 5-4 decision where each member of the majority had a different opinion. The court decided that in order for states to reinstate the death penalty, they had to remove all arbitrary or discriminatory effects in order to satisfy the 8th and 14th Amendment. The court wrote a 1-paragraph per curiam that the death penalty in this case was a cruel and unusual punishment, thus was not sentenced to death. Justice Potter Stewart also showed concern for racial bias against African Americans within many death penalty sentences. He wrote, "These death sentences are cruel and unusual in the same way that being struck by lightning is cruel and unusual. For, of all the people convicted of rapes and murders in 1967 and 1968, many just as reprehensible as these, the petitioners are among a capriciously selected random handful upon whom the sentence of death has in fact been imposed. My concurring brothers have demonstrated that, if any basis can be discerned for the selection of these few to be sentenced to death, it is the constitutionally impermissible basis of race. See McLaughlin v. Florida, McLaughlin v. Florida 379 U.S. 184, 1964. But racial discrimination has not been proved, and I put it to one side. I simply conclude that the 8th and 14th Amendments cannot tolerate the infliction of a sentence of death under legal systems that permit this unique penalty to be so wantonly and so freakishly imposed." Thurgood Marshall also had similar writing where he said, "No matter how careful courts are, the possibility of perjured testimony, mistaken honest testimony and human error remain too real. We have no way of judging how many innocent persons have been executed, but we can be certain that there were some." The dissents were Chief Justice Warren Burger and Justices Harry Blackmun, Lewis F. Powell, and William H. Rehnquist, each appointed by President Richard Nixon. Warren Burger wrote, "In the 181 years since the enactment of the 8th Amendment, not a single decision of this court has cast the slightest shadow of a doubt on the constitutionality of capital punishment." The result of this case was the vacating of over 630 death penalties, and all pending death sentences at the time were reduced to life imprisonment. Over the following 4 years, 37 states created new death penalty laws with the intention of avoiding the court's arbitrary imposition towards the death penalty. In 1976, a similar daughter case was held that followed Troy Gregg, who was found guilty of murder. Gregg argued that the death penalty in itself was unconstitutional. The ruling for this case was a 7-2 decision that stated the death penalty in itself did not violate the 8th or 14th Amendments. Thank you for listening.